Good evening from a rather chilly Johannesburg this evening. And then from a Lenmed perspective, I'd like to welcome all of you to our first ethics CPD discussion or conversation. This is the first in a series of ethics CPD talks that we'll be running from a Lenmed perspective. We're going to be talking about a couple of topics, interesting topics, a modern approach to palliative care medicine that impacts all of our daily practices. So that's the next one coming in August, I think. And then one later in the year, we'll be talking about informed consent. Tonight in particular, we're going to be talking about the law and the deceased, and recognizing that as clinicians, we have a responsibility to do what's in the best interest of the patient while they're alive and after their death, and also make sure that we follow the correct procedure, recognizing that ignorance of the law is actually no defense. I want to take a minute just to acknowledge Genoa for their sponsorship of this event and for the background work that's gone in. Also want to shout out to the team at Genoa and Lenmed for all the background work in putting the event together. And then also a welcome to Professor Vellema, who's joining us from Hermanus down in the Cape, where I'm sure it's a little bit warmer than up here in Gauteng. And then I want to introduce Professor Morgan Chetty, and thanks to Professor Morgan Chetty, who's joining us from our eThekwini Hospital and Heart Center in KwaZulu-Natal. Prof. Chetty is the chairman of he's given me a very short introduction. I was expecting a few pages, Prof. But a very quick and short introduction. Prof is the chairman of the Independent Practitioners Association Federation and Foundation, and he's the chairman of the KwaZulu-Natal Doctors Healthcare Coalition. And I'm going to hand over to Prof to introduce Professor Vellema, and then we'll get on with the CPD. Thanks very much all of you for joining, and I'm looking forward to an interesting presentation by Prof, but also followed by some meaningful conversations. On your screen, you'll see a chat function, and that's the function where you're going to be typing in all your questions. And don't wait to the end; keep typing them in throughout the presentation. And Prof. Chetty and Prof. Vellema will start looking, and I will address some of those as we get to the end. So Prof. Chetty, over to you, and thanks everybody.
Thanks, Nilesh, for inviting me to facilitate tonight's function. I also think, and I said to Dr. Prof. Vellema, is that we're living in such a litigious society. This topic is very appropriate, and it also helps to equip us in terms of the number of issues that the last few must have really taken cognizance of days when we were at medical school or working in a hospital. So I think it's very important. So I'm going to say just a little bit from my perspective, and then just drop down. I think death of a patient is always a significant event. However, the unexpected death of a patient is immeasurably more significant and can seriously impact the physician, challenging his or her ability to cope. There are several reasons for this, and it ranges from the professional perspective. Was the death due to incompetence or negligence? Were other professionals involved and could have foreseen death or avoided death? And there are a lot of confounding variables that we get, and this is psychological factors, spiritual factors, cultural factors that can impact our rational thinking and our management of that situation. However, one factor can be overlooked, and it concerns the ethical legitimacy of the feelings that are being experienced, and centers on three notions that are basic to medicine as a profession. These are the notion of patient, the concept of healthcare, and the nature of medicine itself. So tonight, we're very fortunate that Prof. Vellema will lead us through the dilemma that we find ourselves facing and guide us to do what is morally, ethically, and legally expected. So I'm going to take a short time to shorten Prof. Vellema's already shortened CV, and I hope to do justice to it. Prof. Vellema was jointly appointed as head of the clinical department and the head of the academic Division of Forensic Medicine and Pathology in 2008, where she served until her recent retirement at the end of March 2022. She currently serves as an honorary staff member in the Business Division of Forensic Medicine. During a full-time tenure at BITS, she served on numerous BITS Faculty of Health Sciences committees, and in 2009, she was elected as chairperson of the BITS Professional and Ethics Standards Committee, which she's chaired until 2020. She has performed more than 10,000 medical legal death investigations during her career and has appeared as an expert witness and assessor on numerous court cases. Previously, she worked as a full-time district surgeon in Johannesburg for a year, attending to the examination of and forensic evidence collection in hundreds of rape victims and drivers arrested for driving under the influence of alcohol. She has been the author and co-author of several academic, legislative, policy, and guideline publications, including the scientific journal articles and chapters in textbooks. As a member of the National Forensic Pathology Group, she contributed significantly in co-authoring and editing the National Code of Guidelines for Forensic Pathology Practice in South Africa, as well as in drafting of the regulations to the National Health Act regarding forensic pathology services in South Africa. Internationally, Prof. Vellema has served on the Board of Scientific Advisors of the International Forensic Center of Excellence, INFORCE, the investigation of genocide. I'm sure you will agree with me with this brief introduction. You will concur that Prof. Vellema is superbly qualified to address us this evening. Please join me in welcoming Prof. Vellema to lead us through this webinar.
Thank you very much, Prof. Chetty and Dr. Patel, for that introduction and for the invitation. This is obviously an area near and dear to my heart, and I think it's incredibly important from an ethical and professional perspective that doctors have a deep understanding of the important role that they play when and if their patients should die. So I hope I can address some of the difficult issues. Doctors don't like thinking and working with the law, but we have in fact, very critical role to play from a legal perspective when our patients die. So I'm going to switch off my camera on my side so that we don't consume any unnecessary bandwidth, and I'm going to go ahead with the presentation. Thank you very much again. Oh my goodness. Now it's not progressing. Okay. Whew. All right, so what I'm going to start with is taking us through who and what the Forensic Pathology Service is in South Africa and what should happen by law following the death of a patient, what is an unnatural death, or also known as non-natural or other than natural. The reason there are all these different descriptions is that in different laws it's expressed differently. Some talk about unnatural, some talk about non-natural. They're all the same. They all mean the same thing at the end. I don't want you to get all mixed up with that. And then when do we need consent or authorization, and for what? I think those are very important issues that we have to be comfortable with. So the South African Medico Legal Death Investigation Service is quite different to what happens internationally. So in South Africa, the Forensic Pathology Services are the custodians, shall we call it that, of all unnatural death cases, as per the Inquest Act. And our core business in the Forensic Pathology Service includes providing an equitable medico-legal investigation of death service, establishing cause and, where possible, circumstances of death, and gathering, very importantly, whatever evidence may be required to facilitate the criminal justice processes. And the objective is to ultimately assist in the prevention of non-natural deaths and to assist in the prevention of and the fight against the scourge of crime that we are all experiencing. In the past, this service was jointly provided by the Department of Health and the South African Police Service, with a medical service component being a subdivision of the Department of Health Provincial Services Directorates. And in major centers, many of the doctors, not all, were able to get joint appointments at universities to provide for medical case management, teaching, and research. The support component was a national function of the SAPS, and it was concerned with maintaining a statewide network of medical legal facilities, providing and maintaining equipment, transport, IT, infrastructure, logistics, procurement, and supplies, and providing and controlling the operational and support staff. And then Cabinet resolved in April 1998 to transfer the medical legal, or what was called then the government mortuary services, from the police to the Department of Health, with the reason behind and the thinking behind that being it would be more ideal to provide a completely independent medical legal investigation of death service. It was strongly felt that SAPS couldn't be the custodians of the bodies because of possible conflicts of interest, in that they themselves may have been involved as perpetrators. And we know historically in South Africa that we've been through this in the past, of the homicide or culpable negligence. And they can't be investigators of SAPS-related deaths and also custodians of the bodies of the relevant deceased. And this situation had been widely criticized by, amongst other things, many human rights organizations, the TRC, all of them requesting a change to a more enlightened international practice. And the goal was really to improve public confidence in professional independence and integrity of the Forensic Pathology Service under the Department of Health, rather than the South African Police Service. And certainly in those days, I don't think it's necessarily quite as much anymore, but doctors had a societal reputation of being trustworthy. From the past into the present, so on the 1st of April 2006, this transfer of the service took place from the SAPS to provincial health departments. And the new title given to the service was the Forensic Pathology Service. And ideally, there should have been a single national independent body to provide the service. But as it turned out, the service was devolved to provinces, creating a lot of difficulties in coordination and service standards. And now both the medical and support components reside under the Department of Health, and the various heads of health in provinces are responsible for forensic pathology services. What happens is that assignment or referral of cases to the Forensic Pathology Service is governed by some key acts or laws, with unnatural deaths now being defined for the first time in law in the regulations regarding the rendering of the FPS. And these are regulations to the National Health Act. And there are in particular 3 important acts or laws governing procedures to be followed when a person or patient dies. And these are the Births and Deaths Registration Act, the Inquests Act, and the Health Professions Act. And I definitely am not going to bore you with the lengthiness of each act, but I'm going to extract the portions that are very germane to all medical practitioners relating to patient deaths. Just to tell you a little bit about how we operate in Gauteng, we are an enormous service actually in Gauteng. We have 11 facilities in Gauteng. In the Southern Cluster, we had 8 facilities. That's where I was chief specialist and where I retired from. And in the Northern Cluster, and the Southern Cluster is affiliated to WITS, and I still am. And in the Northern Cluster, affiliated to Sefako Mogatu and Pretoria University, and they've got 2 largish facilities there, as well as 1 small mortuary in Bronkhorstspruit. And this is just to show you the clustering of the facilities, the idea being that they were placed where the majority of the population in Gauteng work and live, in order to render sort of a fairly widely dispersed service. Right, so we're going to get, by the way, we do about 20,000 medico-legal death investigations in Gauteng now. It's actually quite significant. We do more than a quarter of the country's medico-legal death investigations in Gauteng, but we are very densely populated. So I suppose it makes sense. There are three very important acts, as I've alluded to earlier on: the Births and Deaths Registration Act, the Inquest Act, and the Health Professions Act, that guide legally what should happen when a patient dies. And I'm going to start with the Births and Deaths Registration Act, because this is the particular act that has custody, shall we call it that, of the DHA 1663. Anybody who's ever worked in an area where like a trauma center will, you know, where patients die, unfortunately, more frequently because of injuries, will be very familiar with the DHA 1663. And what it states in section 15, it talks about the certificate by medical practitioner. This is the DHA 1663. And what it there states is that if a doctor is happy that a death was due to natural causes, he or she shall issue the prescribed certificate, which we now know it's been through many names in the past, but currently it's the DHA 1663, stating the cause of death. It also states in that section that even if a medical practitioner didn't attend a person before their death, because we live in a country where everybody isn't fortunate enough to have an exclusive medical practitioner. Oops, sorry. Did I move my screen? No. I did. I beg your pardon. Even if it wasn't your patient, and somebody presents in a emergency room setting, as long as the doctor examined the corpse, the body, the corpse, they use the term corpse, and is satisfied that the death was due to natural causes, a doctor may actually issue the prescribed certificate, the DHA 1663, to that effect. So we don't have the limitations that they have in many other first world countries, where if a patient hadn't been attended to 2 weeks prior to their death, nobody may issue a natural death certificate. We don't have that luxury here. And this means that not every DOA in an emergency room is automatically considered an unnatural death, or a death that must be referred to a forensic pathology service. So it states further that if the medical practitioner believes that the death was due to other than natural causes or unnatural causes, he or she shall not issue the DHA 1663 and shall inform a police officer. So it's got to be reported to the police about this opinion. And it means that in this type of unnatural death, a medico-legal post-mortem examination, a SAPS investigation, and a judicial inquest or even criminal court investigation must be held. And it also means no consent is actually required from families for all of these processes to be followed. So the fact that it's stated like this in the Births and Deaths Registration Act makes it quite difficult to handle the forms, because the forms are somewhat contradictory. When I get to it, I'll point it out to you. The following in the Births and Deaths Registration Act, this is something interesting that I think many people don't realize, is that there are few offences in that act. One, the obvious one, is failing to inform the state of a birth or death. Another one is giving false information to the state about a birth or death. And what I want to highlight there is sometimes doctors sign bodies out as natural because they think they are doing a family a favor, and they're actually committing offense in doing so. And the typical cases where this will happen are in sudden infant death syndrome deaths, where the families are very upset. You know, they've just lost a baby was found dead in a crib, for example, and family doctors feel sorry for the families and they issue natural death certificates. So our figures, for example, for sudden infant death syndrome or SUDIs, sudden unexpected death in infancy in Gauteng, are really very, very skewed, because I do believe that these kind of cases are being signed out as natural by doctors, and that is giving false information, actually. Then counterfeiting any document. Now, us people in forensics who work a lot with DHAs, we've encountered many incidents where our signatures are falsified for insurance purposes on death certificates. So this is something we deal with quite a lot. And then another thing doctors don't realize, if you unreasonably withhold a certificate, you don't feel like doing the DHA 1663 or whatever the reason might be, but you're unreasonable about it and you're not signing it, it's actually considered an offense as well. Then we have the Inquest Act, and it provides for the holding of inquests, so legal inquiry, in cases of deaths or alleged deaths apparently occurring from other than natural causes, and for the matters related to that. And it provides for the reporting of these unnatural deaths, the investigation into the circumstances of the deaths, the actual procedures to be followed at the inquest, what the findings are at the inquest should be, and then sequelae and offences and further legal processes. And what this particular act states is that any person who believes that somebody has died of unnatural causes shall is a very strong word in the law, as soon as possible report this to the police, unless they believe somebody else may have done this reporting. It allows for an inquisitorial legal investigation before adversarial legal processes are instituted. We've got an adversarial legal system in South Africa, if at all. What we mean by inquisitorial or inquest processes, here the inquest magistrate is actively involved in investigating. It's an inquiry, the facts of the case. Whereas in terms of adversarial or criminal processes, the judge's role is primarily that of an impartial referee between the prosecution and the defense until the outcome is finally decided. When it comes to reporting other than natural death, the medical practitioner has to know what is implied, what is meant by other than natural or unnatural causes, as defined now in the regulations regarding the rendering of FPS. And the medical practitioner has a statutory, a legal obligation, like any other person, to report this death. And failing to do this actually constitutes an offence. The Inquest Act, when it comes to the cause investigation into cause of death and circumstance of death, states that the body of a person who has allegedly died from other than natural causes shall, strongly shall, be examined by a forensic medical practitioner. They still use the terminology district surgeon, who may examine or cause to be examined the internal organs, any part of the body, any substance or thing related to the body to determine cause of death, and thereby assisting the police and the courts with the circumstantial investigation. So this is a must. If somebody has died of or is believed to have died of unnatural causes in South Africa, they must have a medico-legal death investigation. And you do not need the permission or consent from families to refer such cases. In fact, you're committing an offence as a medical practitioner if you don't follow the correct procedure. If you, in other words, falsify the DHA and say it's a natural death when you actually know it should be a death that should be reported and investigated. It also states in the Inquest Act that any part of the body may be removed from the body and to any other place for the purpose of this medico-legal death investigation to ascertain with greater certainty the cause of death. It also states that the body may be exhumed for said examination with the written permission of the magistrate within whose area of jurisdiction it has been interred. And, you know, people often joke about doctors burying their mistakes. Well, it's not that easy in South Africa. It's actually fairly well covered in law. And it happens that these exhumations. Then we get to the Health Professions Act. And this is an important one because it's still causing confusion. So what it stated before August 2008, it only spoke to anesthetic deaths, and it said that the death of a person while under the influence of general, regional, or local anesthetic, or where the administration of an anesthetic has been a contributory cause, shall not be deemed to be a death from natural causes. And it meant that in all those types of death, a medico-legal post-mortem and inquest had to be held. Again, no consent required. But the law was changed and it's become a lot broader. And it was proclaimed as this much broader law on the 1st of August, 2008. And what they did is they changed the whole, you'll see in green there, the death of a person now undergoing or as a result of a procedure of therapeutic or diagnostic or palliative nature, or where any aspect of such a procedure has been a contributory cause, shall not be deemed to be a death from natural causes. So, and again, no consent from families would be required. The problem with this particular section is that when this was changed, we as a National Forensic Pathology Services Committee immediately wrote to the lawmakers in this regard and said, you know, this is incredibly broad. If you make the procedure simply one that's defined as therapeutic, diagnostic, or palliative, because it actually means that every single patient who dies on a hospital, I mean, the only reason why you would be admitted to a hospital is that you're busy undergoing some kind of therapeutic, diagnostic, or palliative procedure. The way you've written it now, it means that every single one of those hospital patients would have to be admitted or referred for medical legal death investigations, and the service isn't set up to deal with that. There needs to be a step in between, so a death review committee of sorts, or we need to define it better. Despite our numerous appeals to actually define this better, and in fact suggestions and proposals that we wrote for them, which they agreed to, it was never actually published. So now, you know, we kind of have to be pragmatic about it. And what we do to overcome this somewhat gray area dilemma is to say that the procedure must be an invasive procedure, a surgical procedure of therapeutic, diagnostic, or palliative nature. It can't just be you were busy taking a diagnostic, doing a diagnostic procedure of taking a blood pressure and the patient dies, and now suddenly it becomes a medical legal death investigation. So that's the pragmatic course to take, but it is a gray area for a lot of people. They struggle to make the decision in the whole procedure related domain. And I always advise people that if you're uncertain, contact your local forensic pathology office service and try and get clarity from them. And I often get phoned by doctors still, and I walk them through what it is that they're battling with. And in the end, they usually know exactly how to choose, how to elect what to do about a particular case. The definition of unnatural death. When we wrote the regulations for the first time in 2006 and 7, we developed a definition, a legal definition of unnatural death. And it's not that complicated, but I think that there's some unexpected things for many clinicians. So the easy ones are any death due to a physical or chemical influence, whether direct or indirect, or their related complications. So any kind of accident, injury, poison, drug related death would be considered unnatural, or their complications therefrom. This one, the next one, people often don't realize, so that even if a death is natural, but it may have been a result of an act of commission or an act of omission, which may be criminal in nature, it's considered an unnatural death. So this is where families can report a death to the police, and even if it's a natural death, and if the police are convinced that the circumstances were such that somebody else may be culpable or criminally responsible, then they can actually open a police case file, and the case can be referred to us for medical legal death investigation. And then in section C, these are the procedure related deaths that I told you can be quite difficult because of a lot of gray areas in it, but any death as contemplated in section 56 of the Health Professions Act. And then the last one, any death, and it's an important one, which is sudden and unexpected or unexplained, or where the cause of death is not apparent, is considered an unnatural death until proven otherwise. And again, for any of these, you do not need agreement or consent from families to refer such cases, to report it to them to the police, or to refer them for medico legal death investigations. So, number of things that the doctor must do when a patient or a person dies. They have to certify or declare the death, and define legally, according to the National Health Act, simply as brain death, which, as you know, is a very broad definition, and from time to time, actually the criteria for this have been adjusted over the years. Then they've got to decide as a doctor, is the death due to natural or unnatural causes? So one has to know the legal definition of natural or unnatural death, and then decide whether to issue the DHA 1663 in accordance with the Births and Deaths Registration Act, the Inquest Act, and the Health Professions Act as amended, and then the regulations which define what an unnatural death is. If it's a natural death, i.e., using the wording in the DHA 1663, where the death was solely and exclusively the result of a natural disease process, this is in accordance with the Births and Deaths Registration Act, so it's not a death precipitated by trauma or a procedure, the doctor may issue, and in fact must issue, the DHA 1663 notice of death or stillbirth, and must indicate the cause of death. If it's a death due to unnatural causes as defined in the regulations, the doctor may not actually complete the DHA 1663, must inform the SAPS, and must refer the case to the Forensic Pathology Service for medico-legal post-mortem examination. And again, no consent from families required to do this referral and reporting to the police. And many of you will know these forms. They're printed really tightly, and I'm showing it to you like this, but I'm going to go and zoom in the next slide. Under section B, that certificate by the attending medical practitioner or professional nurse. And section G1, very important for clinicians. So the problem with section B is it actually is contrary to what is stated in the Births and Deaths Registration Act, even though this is their form, because they, in the Act, state quite clearly that if a death is due to unnatural causes, this form should not be completed by the clinician. It has to be referred for a medical legal death investigation. And yet they give clinicians the option here, very closely aligned, those two blocks there, the 22.1 and 22.2, In 22.2, it says either undersigned am not in a position to certify the deceased died exclusively due to natural causes. And the problem I have with that, more than anything else, is in real life, those two blocks are incredibly close together. And if a doctor's pen just touches the wrong block, the one up there that says that the death was exclusively due to natural causes, undertakers are very quick to remove bodies like that before they've even had a chance to get to medico-legal death investigation. So what I always say to doctors and what I advise is that if you believe the death is due to unnatural causes, don't complete the DHA 1663, because then nobody can commit fraud with it, nobody can run away with it. And we issue new DHA 1663s in any case when the bodies come to us for medico-legal death investigations. There are other forms that doctors should be completing, which I'll go through with you. In terms of completing that cause of death section, this is what it looks like. You start with a terminal event or the immediate cause at the top, and then it goes due to, and right at the bottom is the initiating or underlying cause of death. So what, just to remind people of the difference between a cause. Sorry, I hope you can hear me again. I was muted there for a minute. So, what is a cause of death? It is basically the primary underlying cause of death. It's the disease or injury which initiated the train of morbid events resulting in death. So, for example, a blunt force head injury, which is unnatural, or meningococcal meningitis, which is natural. A mechanism of death would be the pathophysiological derangements resulting from or following on this primary cause of death. So, for example, cerebral edema with raised intracranial pressure, these are mechanisms, and status epilepticus due to the cause, blunt force head injury if it's unnatural, or meningococcal meningitis as an example if it's natural. Manner of death would be the circumstances. How did this cause of death arise? Whether it's natural, accidental, suicidal, homicidal, or undetermined, that's manner of death. And then the final formulation of a cause of death as per the DHA 1663 in section G, to give you an example, is status epilepticus right at the top, that's the terminal event, due to raised intracranial pressure, due to, and here it can be anything. It can be blunt force head injury, which is unnatural, or it could be meningococcal meningitis. So you can see that the mechanisms may follow on either natural or unnatural pathology. Oh gosh, now I'm stuck again. There we go. So here's an example of what it looks like in the DHA 1663. Immediate cause at the top there is status epilepticus due to raised intracranial pressure, due to cerebral edema, due to, and here it could be either blunt force head injury, that would be us in forensic pathology services, our doctors would be completing that, whereas if it's a patient who died in the ward of meningococcal meningitis, then a clinician can obviously complete the death certificate without any kind of medico-legal referral, and then there may be underlying conditions contributing to the death but not resulting in the underlying cause. I've just given you an example of advanced liver cirrhosis. I just want to remind people, if you list a surgical procedure here under causes of death, you can't then go and sign it out as natural, because it effectively means the procedure contributed to the death, which is then by definition under the Health Professions Act, unnatural. So please, if surgical procedure or intervention played absolutely no role in the death, then don't list it under these causes of death. It can be in the patient's bed letter and in the file, and they may have had their surgery years before, whatever, but don't list it here unless it actually really contributed significantly or resulted in the patient's death. Okay, just remember that. So there are forms that have to be completed, as with everything else in life. So if it's a procedure-related death, there's a form GW 724. That's a national form that has to be completed by the surgeon and the anaesthetist. And then in Gauteng, we call our clinical history form a D28. And this is normally completed by the medical practitioner in charge. In unnatural or sudden unexpected deaths, the form D28, where there's no procedure being performed, the D28 would need to be completed. It basically includes clinical summaries, wound descriptions, and evidence retained. For example, there may be bullets in the clothing of a victim when they're examined in the emergency room in gunshot wounds. If there's no procedure performed, only the D28 by the medical practitioner in charge. If a procedure was performed, again, surgeon and anaesthetist have to complete GW 7/24. And then very importantly, if it's an unnatural death, the police have to issue a form called SAPS 180 in South Africa. And this is meant to give a circumstantial history, and the important thing here is this is the form that authorizes the forensic pathology service to remove a body from a scene or from a hospital for a medico-legal death investigation. What is important about it is that if this form isn't issued, then the police don't do a proper police investigation. They don't open a docket. And then all of this effort is for naught. So we are very insistent, and our staff will be adamant about having these forms, the D28, the GW 724, where necessary, where procedure has been performed, and they must have the SAPS 180 before they will remove a body from a hospital or from a scene. Findings at the inquest are also governed by the Inquest Act, and basically here the inquest magistrate has to record the following findings. The identity of the deceased, you won't believe how difficult that can be. We have up to and sometimes over 1,000 cases a year in Gauteng that are never identified. The cause or the likely cause of death, the date of death, and whether or not this death was due to an act or an omission on the part of any person. In other words, might they have been negligent, which would amount to an offence. And these findings are then submitted to the DPP for further prosecutorial decisions. Just a few words before we're nearly at the end about consent and the Constitution of South Africa. Particularly Chapter 2, the Bill of Rights. So the Constitution is the supreme law of the land, and all legislation and conduct must conform to it. And why I specifically refer to this is because of this issue of the consent thing. I can't decide what happens to my loved one's body and whether I want a medico-legal autopsy or not. So, and then the Bill of Rights basically in Section 8 binds the legislature, the executive, the judiciary, and all organs of state. So the Bill of Rights cites 3 rights that are often cited when considering bioethics of forensic medicine and the law, and this is particularly relating to consent. And what families will often try and use to refuse, shall we say, the medico-legal death investigation is that they believe that it's unconstitutional. There's an infringement on their right to human dignity, their right to freedom and security, and their right to freedom of religion, belief, and opinion. But what people often forget in the same vein is that the Constitution is much broader than just those three. It also talks about equality, saying that everyone is equal before the law and has the right to equal protection and benefit of the law. And ultimately, the laws have been written to protect and benefit everybody. So although these constitutional rights are fundamental in our society, they're still subject to the limitations of rights in Section 36 of the Bill of Rights, provided such limitations are reasonable and justifiable. And we know that we've experienced what we've all perceived as infringement of our rights during COVID, with numerous regulations that were written and changed and updated all the time. And a lot of that was happening despite people feeling that it was an infringement on their choices. And it basically amounts to the same thing. It was felt at the time that those infringements under Section 36 of the Bill of Rights were reasonable and justifiable in the light of the pandemic as it was. So Harry de Waal said the following, that constitutional rights and freedoms are not absolute. A law that limits a right infringes a right, but such infringement will not be unconstitutional if it takes place for a reason that's accepted as a justification for infringing rights in an open and democratic society based on human dignity, equality, and freedom. And there are a number of criteria that would have to be considered: the nature of the right, the importance and purpose of the limitation, the nature and extent of the limitation, relation between limitation and its purpose, and whether there are less restrictive means to achieve the purpose. So the Bill of Rights prescribes the actual bounds of permissible intrusion into the sphere of individual rights by the justice system. I'll give you an example, and this is something we are confronted with quite a lot. A young Jewish, Muslim, Hindu, Christian, Buddhist male child dies after being shot in the chest during a car hijacking. The family object to the medico-legal autopsy on the basis of religious or cultural or personal beliefs. And you have to ask yourself, should this death not be investigated? Which as a consequence will have that the evidence won't be retrieved. So for example, the spent projectile, and therefore not analyzed. And this also means that the person who killed this child would not have to face the consequences of his or her actions, and actually pose a significant threat to the rest of the population. So should the rest of society not be protected against this responsible criminal? And it comes down to this: regardless of religious or cultural or personal beliefs, the answer will always be that a medico-legal investigation is required to gather and document the relevant evidence to serve the judicial processes, and very importantly, to benefit everybody equally in a conviction of this criminal. And a reminder again about equality. Everyone is equal before the law and has the right to equal protection and benefit of the law. It's obvious that performing medico-legal autopsies on only a selected population, so those who actually want to or agree, and excluding other individuals based on religious, cultural, or personal views, it would be discriminatory and unequal and undoubtedly harmful to the rest of the South African population. There was a speech by the former Deputy Chief Justice Dikgang Moseneke, which actually explained it quite well, the limitations of the Bill of Rights in terms of protecting the well-being of all South Africans, despite religious affiliation or lack thereof. And basically what he said is that every right guaranteed in the Bill of Rights may be limited by a law of general application, such as the Inquest Act, the Birth and Death Registration Act. Thus, the right to religious freedom is not absolute. Its scope may be limited by other rights or by a law in pursuit of a legitimate government purpose. So a law in pursuit of wanting to track down and take criminals to the through a criminal justice process would be a very much a legitimate government purpose to benefit everybody equally. The purpose of all this legislation, the procedures and the forms, it absolutely is to protect the public from each other and from unscrupulous healthcare. But it's also to protect medical practitioners from random, unsupported allegations or accusations. Often medical practitioners feel very pursued by having to complete all these forms. And that really isn't the purpose behind it at all. It's a factual gathering of information. It's not it shouldn't be, and it isn't actually an accusation. It's just simply making sure that the data is captured and supported by the medical legal death investigation process. And then everything I've just said, all these long things, it's basically captured in this one sheet about how to handle deaths due to unnatural causes on the one hand and deaths due to natural causes on the other. And what it amounts to is that ultimately the Forensic Pathology Service will do the medical legal death investigation and complete the DHA 1663 in unnatural deaths, whereas and these DHA 1663s have to go to Department of Home Affairs to register deaths for actual death certificates to be issued and burial orders to be issued. It's a much simpler process if it's a death due to natural causes, because these notices of death are completed by clinicians at hospital level usually, or clinical level. The last one or two slides that I have is just something to remind people about the donation of tissues and bodies. So we have the National Health Act, which in Chapter 8 talks to the control of use of blood products, tissues, and gametes in humans, with a whole lot of regulations having been drafted regarding the general control of human bodies, tissue, blood products, and gametes. And what you need to understand here, donation means the donation of a human body, blood, or any specific tissue in accordance with the Act, and donee means the recipient, means an institution or a person to whom a body, blood, gamete, or tissue has been donated. It's very important that to be aware that the Act very clearly specifies what donations may be used for. And the list is fairly short. It's for training of students in health sciences, for health research, for advancements of health sciences, and for therapeutic purposes. And then there's also provision made for the donation of unidentified, unclaimed, or destitute bodies after all steps have been taken to locate the family. And why I want to raise this with you is that you may be confronted from time to time with a patient who is a beating donor. So they may only have, for example, a traumatic brain injury, and the family will come to you, approach you and say that they know that their loved one is brain dead, but that this was he or she was an organ donor and they would like to donate the tissues. And what is important for you to be aware is that consent can be given for such beating donations, but it's important that you be aware. What it says in the National Health Act is, despite anything, and it's circled in red here, to the contrary in any other law, a medical practitioner who conducts a post-mortem examination in terms of Section 3 of the Inquest Act, that's us, the Forensic Pathology Service, we have to remove or cause to be removed from bodies any tissues for donation and hand it over to the relevant recipients, the institution or person. But it's very important here that the removal may not be effected if it is likely to affect the outcome of the examination. So some of you who work in the tissue and organ donation realms and have a lot to do with this will know that if it's an unnatural, or it's going to be an unnatural death, that we are contacted in the forensic pathology services to ask us whether, for example, in a patient with only a traumatic brain injury, who is a donor, whose family, who's a known donor and whose family have also consented, whether they can remove the heart or valves or particular tissues for donation. Just be aware of it, that it can't just be done because the family have consented, that there is a process to be followed if it's an unnatural death, because we have a big problem in the forensic arena. If organs or tissues have been removed that may be vital to contribute to the evidence that we may have to gather in a particular case. Okay, so tissues to be used purely for research need consent and ethics approval. But please be aware that this does not apply for the legal tissue, the tissues that we collect as evidence in the medical legal arena. We don't need consent for that. We're already doing it for medical legal purposes. For health research, all proposals require approval by an accredited human research ethics committee before research may start. That's in Chapter 9 of the National Health Act. All autopsies to be conducted in natural death patients also require consent, and the people who may give consent are in this particular sequence of preference: spouse, partner, major child, parent, guardian, major brother, or major sister. In that specific order may consent. And for those of you on Gauteng and who may be shocked by the numbers I've given you before, there's a wonderful facility being built behind Helen Joseph Hospital. It'll be the new Johannesburg Forensic Pathology Service facility. It's 4 years delayed in completion. I've been showing this slide now for quite a few years, and I keep having to change. It started with it's going to be completed in 2018 and then 2019, and then COVID came and everything came to a standstill. Well, now we're hoping next year that they will complete it, and it's going to be a wonderful facility to serve probably most of the province. Thank you very much. That's it from me. I'm handing back over to our organizers.
Thanks very much, Professor Vellema. I'm waiting for Prof. Chetty to come back online. Prof, are you back online?
Hi, Nish, can you hear me now?
Yes, we can. Thanks, Prof. Go ahead.
Thanks, Prof. Thanks for
Maybe, Prof. Chetty, before we take the questions, maybe we should go through the multiple choice questions. Pravashni, do you want to put those up?
Are we going to read them out or just put them up and go through them with Prof there?
Yeah, I think that let's put them up, and then Prof will comment based on the answers that come up. So there's the first one up. So everyone, please complete and select your answers, and the answers will come up, and Prof will comment as the answers come through. Thanks.
May I ask, can the other people see more than, oh, hang on, okay, just stretch your screens. I've just discovered that otherwise you can't read the entire answer. In fact, I still can't read the entire answer.
Let's just see. Otherwise, there you go. Yeah, you've got to scroll. So there's a couple of questions.
Yeah, but so for example, B ends for me at super, and then that's it. So you can't
Oh,
read
that's
the
a
whole.
pity.
If you put your cursor over the A, B, C, D, it reads the entire question. Once you've put your cursor over A, B, C, or D.
I'm doing it and I'm not seeing the entire question.
No, it does come up, Prophet. I am seeing it here.
Does it? Okay,
It does.
because
It does.
It is.
I
Okay.
can
I think
see
it's visible on the big screen now.
But how do you submit? Once you've selected an answer, it won't allow me
No.
to submit my answer.
There's a
Vivash?
submit command at the bottom.
Yeah, mine's not highlighting and it won't allow me to do it.
Let me see what's going on because mine is showing that it's a poll.
Can I just say you have to answer all of the questions before it allows you to submit. You can't just answer the first question, make it bigger, and then you have to do all of them before you submit.
Okay, I get it.
thank you. Okay, and one can just scroll through it. I can see now. You can just, okay, perfect.
I think the best thing to do is to allocate a time in which the question should have been done and allow Prof to come back and to go through the answers.
So on Zoom, unfortunately, it works differently that all have to be answered before it will process the poll percentage. We have 157 participants and 2 have only submitted so far.
So maybe what I suggest is, Prof, could we put up the slides with the questions and let's just go through the questions and let's see what, maybe we can ask people to put the answers into the chat box, because I think this poll is taking a bit longer than we anticipated.
Okay, let me just go, let me just get out here again.
I will leave the poll up.
That's fine. You can leave the poll up, but I think let's maybe put up the questions so we can then maybe get people raising their hands if they'd like to comment on what they think on the question, or Prof, you're winning.
Yeah,
Can you see it?
We can see the presentation, but not the questions yet.
Now? Can you see it?
I can't. Not yet. No.
Really?
No, it's just the PowerPoint presentation.
So you don't see MCQs?
I'm seeing the PowerPoint open with the first page of your presentation, and it's not in PowerPoint. It's not in presentation mode.
Okay, let me just close this one then.
You may have 2 copies of the presentation open.
Yes, I'm just going to reshare it.
In the meantime, maybe we could cover the one question that was raised in the box. But there we go.
Thank you.
All right. Do you want to put that in presentation mode, Prof? And let's look at that question.
Right. Really, it's an ER doctor is asked to complete the DHA 1663 for a patient who is DOA at the hospital, and the history was the patient suffering from terminal cancer, had elected to die at home. However, when the patient started gasping, we see this a lot, the family panicked, they rushed him to hospital in their vehicle and he died en route. The ER doctor is unsure as to whether he or she can complete the DHA 1663. Which statement is correct? And then I've taken people through a few options, and I think that if you got to D, which is that the ER doctor may complete the DHA 1663 after due consideration of the history given and after examination of the decedent's body. This is very important. You can't just do it on a verbal. If it supports a solely and exclusively natural death, then the DHA can be completed. Do you want me to go to the next one?
I think let's move through the questions, Prof. And then if anyone does have questions, please type them into the
Okay.
box or raise your hands and Prof.
Okay.
Chetty will come to you.
So the next one, which of the following statements is correct pertaining to the National Health Act, the regulations regarding the rendering of forensic pathology services? Would be B. I don't know. Do you want me to read through all of them? Dr.
I think we
Patel,
can read through the options, and you very kindly have
Okay.
highlighted the answer.
Option
part,
A,
so-
besides conducting the medico-legal post-mortem investigations, the FPS is also responsible for the appropriate burial of all deceased individuals. I hope you didn't choose that one. B, the provision of an equitable medico-legal investigation of death service towards establishing cause and circumstance of death is a fundamental ethico-legal mandate of the FPS. C, the FPS is not at liberty to request hospital records and conduct special investigations relating to a deceased individual. We are, in fact, this responsibility belongs solely to the SAPS, not at all. Under our own, under the regulations for our service, we may actually also request hospital records, and we're entitled to receive them. D, archiving of documents, specimens, and related materials is not essential to the FPS core functions. It very much is. So it's B. Next one. A 53-year-old rabbi is admitted to a hospital with signs of severe chronic anemia requiring a blood transfusion. During the transfusion, he becomes short of breath and suffers a cardiorespiratory arrest, and despite resuscitative efforts, he dies. Religion requires that he should be buried as soon as possible. The attending doctor wants to refer the deceased for a medico-legal autopsy, quite correctly so, because it's transfusion-related death, very much procedure-related and very much invasive. Which statement is correct? A, the deceased and his relatives have strong religious beliefs, and therefore the family may refuse consent for a medico-legal post-mortem examination on religious grounds. B, from a legal perspective, the attending doctor must request authorization from the hospital CEO or superintendent for the medico-legal post-mortem examination to be performed. C, a medico-legal post-mortem examination is legally mandated by the Health Professions Act, as amended, and the Inquests Act, and does not require consent. And D, the South African Police Service should be contacted to get consent from a magistrate to perform the medico-legal post-mortem examination in this case. And the correct answer is C. Question 4, a couple returns home from a party to find their infant son is lying dead in his cot. The babysitter stated the child had been well and sleeping peacefully an hour prior to discovering his death. The distraught parents rushed the deceased infant to the emergency room. They confirmed to the ER doctor that the infant had been healthy prior to his death. Which of the following statements is true? A, the ER doctor may elect to sign the DHA 1663 as a natural death. B, infants who die at home while sleeping are known to be cot deaths and don't require medico-legal post-mortem examinations. C, if the clinical examination of the infant's body by the ER doctor does not reveal any injuries, the death would automatically be considered due to natural causes. And D, this is a case of sudden unexpected death in infancy, a SUDI, and by law must be reported to the SAPS and referred for a medico-legal autopsy at the Forensic Pathology Service. Question 5, which of the following statements is or are correct? With specific consideration of South African legislation, A, when a patient dies more than 48 hours after a surgical procedure, there is no legal requirement to report the death to the SAPS or refer the body for a medico-legal post-mortem investigation. B, the Health Professions Act as amended specifically deals with the handling of anesthetic-associated deaths. C, the Births and Deaths Registration Act legislates for the appropriate death notification forms, prescribed certificates to be completed or not completed by medical practitioners. And D, procedure-related deaths are defined in the Inquests Act. I hope you've all chosen C. Last question, with regards to the Constitution of the Republic of South Africa and Chapter 2 of this Act, which pertains to the Bill of Rights, which of the following statements is or are correct? The Constitution for the RSA is regarded as the supreme law of the country. B, the Bill of Rights grants families the right to refuse a medical legal death investigation on the basis of religion and or culture and or personal beliefs. C, the Bill of Rights provides unlimited rights specifically to religious freedom, regardless of any other laws in pursuit of a legitimate government purpose. And D, our Constitution has no hierarchy of rights. All rights rank equally, albeit still subject to the limitation of rights in Section 36 of the Bill of Rights, provided such limitations are reasonable and justifiable, with A and D being correct here. I think that brings us to the end of the MCQs.
Thanks very much, Prof, for those. Can we hand over to Prof Chetty? I think there's one question in the box, and then there's a couple of other questions, Prof. Prof, over to you.
Yeah. We have a few questions, and we have some quite, well, I would say, issues that we as practitioners need to have clear. I think I've taken two questions, and they're almost like overlapping. It's all about to do with anesthetic death. Is there a time frame, say 48, 72 hours, that constitutes an unnatural death, or is it time independent? And a similar question comes up with particular deaths. Is there a time frame, or is it time independent?
In South Africa, there's absolutely no time frame. So it could be a year later. If you sustained, for example, during a procedure, a hypoxic episode, never regained consciousness, it would still be considered a procedure-related death, even if you remained comatose or vegetative for 6 months or a year. So we, unlike the UK and certain states in the USA and in Australia, we don't have a time frame. They actually are strict in a different respect. They say all patients who die within a 24 or 48-hour period become coroner's cases, but that's not the same as having a medico-legal death investigation. We don't have that step in between, and we have no cutoff time. So we don't say if you die after a 48 hours after a surgical procedure, you are not considered procedure related. We look at the correlation between the surgery or the procedure and the patient's death, and whether there's any potential linkage between the death. It basically actually says, even if it's only a contributory cause, that is considered an unnatural death until proven otherwise. So no time frames for us.
Thank you. I'm going to combine the next three questions because they all lead one into the other. And the question is, what is the process to provide feedback to the treating medical practitioner, the health establishment, on the outcomes and findings of a post-mortem examination? In practice, it is hard to get feedback. And then supporting that is, do we have sufficient forensic pathologists for the need? And how well is the forensic pathology services staffed and equipped to manage increasing load? Also fit into that because feedback fits into that as well.
Sorry, you cut out a little bit and I struggled to hear you. Just take it one by one. The first one is the feedback one. I got that quite clearly. The feedback. Okay, so can I just take it one by one? The feedback. Let's do that first. Yeah. The feedback I know is very critical. So what we're not allowed to share reports with clinicians during the ongoing medico legal death investigation. Those reports are considered sub judice. So what we do in Gauteng is that we participate in M&Ms, where we can give immediate feedback, because it's very difficult when somebody phones one of our forensic pathologists and says, I'm Dr. So-and-so, and this is my patient. We can completely understand that somebody may want to know what happened, but we don't know who we're talking to. So while I hate the POPI Act for its inefficiency in many other areas, and I hate it being cited as the end all and be all, this is way beyond POPI Act. It's actually, you know, when we don't know who we're talking to, it really is a risk for the investigation of the case. So the way we try and overcome that is through M&Ms. And when people we developed a template of a form of the information we need, we'll go and draw those cases and we'll present them to the various hospital M&Ms. And we've had a long-standing relationship because of the high numbers of trauma in Gauteng of doing M&Ms, and that's how we can give feedback. We cannot give it in an official paper report format until the conclusion of the inquest or the criminal case.
Okay, thank you. I'm going to lead the next question. And the next question is, who coordinates, contacts, or then gives information to families after a patient is referred for forensic postmortem? In Durban, there are significant delays and families struggle to get information on the progress.
Yeah. This is why we actually wanted our service to be more nationally run than provincially, because we know that there are differing standards and processes in differing provinces. The coordination is supposed to start taking place from the scene. So if it's a death at a hospital, it's supposed to start there at the hospital mortuary, and then it's taken over by the forensic pathology service staff, who are supposed to inform the families about the processes, and that they're supposed to go to the medico legal facility to do an identification, a formal official identification of the body. And they're supposed to give them all the information that they need right there at the forensic pathology service. And ideally, under optimal circumstances, no family should have to wait for longer than 2 days for the completion of a medico-legal autopsy, but the reports and the investigations can take a lot longer. So that's the short version of what it should be. There can be delays because we've had a lot of labor-related delays when staff are strike or on go slow, and we can only do what we can do because you can't render the service appropriately without support staff. So it does differ from place to place, but it should be the service that should be guiding families through this really awful process, actually, from a family perspective.
Yeah, there's another quite a common question that we see in family practice. What are the legal repercussions when medical practitioners certify procedure-related death as natural due to pressure from the family?
Well, they're committing a crime, and pressure from the family is not a defense. There's no defense for committing a crime. You cannot state, I was coerced as a doctor to sign a natural death certificate because the family pressured me. It's not a defense. So you could potentially, if somebody reported this, or if it were discovered, then you would be liable to be charged with a criminal offense. So it's a very serious thing, and I warn doctors about that because they do in fact, a lot of the time, I think, feel pressurized by families. My own experience with families is if you spend a little bit of time and you explain to them why things are happening the way they are and why you as a doctor cannot sign this natural certificate because effectively you'd be committing fraud, and under the Birth and Death Registration Act, that it's an offense. So you as a doctor could have a criminal record for the rest of your life because you try. So, you know, I think that if doctors actually take the time to explain to patients that they can achieve a lot more than they realize. But be very, very careful of that kind of coercion, because you, not the family, your signature on that document is going to be the one that can give you a permanent criminal record.
Thanks, Rob.
So if you ever want to go working overseas, anybody with any aspirations to go work in a different country, you've basically signed and sealed your own denial.
Okay, this is a similar question. Are families able to request a post-mortem examination in a matter where a medical practitioner certifies death as natural?
Yes, if they are convinced that the death is not natural, then they can actually report it to the police. They would obviously have to provide sufficient information to the police to convince them that in fact they of the, shall we say, of the unnatural nature that they believe that the death may be due to. So they can do it. What the police won't get involved in are civil disputes. We are involved with a pursuit of criminal investigations, not civil, where families are trying to get money out of a hospital or money out of a doctor. So that, you know, and I've helped families in the past where they've had difficulty because they believe and they will explain quite carefully what happened and what went wrong. And then they have to put it in a statement to the police, and the police issue the 180 and the body can come to our facility for medical legal death investigation. But we don't do civil cases. So if it's all about money, we don't get involved in that at all. So they actually have recourse.
There's another question that's a little bit more sort of complex, bringing two different issues into one. If a patient dies within 48 to 72 hours after an ENT surgery, that is resection of a tumor, and the patient dies what you clinically or biochemically suspect as a myocardial infarct, can you certify as natural death, or must all patients who had a recent invasive surgery or procedure be deemed unnatural?
No, not all patients who had recent surgery is considered unnatural. How it's stated is that the procedure must have the death must either take place during the procedure or due to the procedure, or it must have contributed to the death. Those three criteria have to be there. So if it's a myocardial infarction 3 or 4 days or even 2 days after the procedure, and it's got nothing to do with the procedure, the patient was unwell, you know, had a cardiac history even before the surgery, and it's got nothing to do with the procedure, that's not automatically a procedure-related death, no.
Thank you. We know that health...
Sorry, can I just say one other thing? The 48 hours and 72 hours, forget that. It doesn't exist in South Africa, okay? Because I think that is tying people up in knots here. Or, you know, it's got nothing to do with the number of hours. It's how you relate that terminal event to the procedure performed.
Thank you. We know that health professionals or representatives of institutions are professionally and morally obliged to assist the bereaved by offering support and information. And this is needed to dispel or to mitigate uncertainty. What information do you share the extent of this information, because you don't want to introduce uncertainty or doubt.
We share very little information with the families. We obviously try and console them, and we assure them that we're busy with an investigation, but we're not really at liberty. You've got to understand we're in a very difficult position. We're not the primary investigators of the circumstances of death. And sometimes we're dealing with pediatric deaths, and there's actually a belief by the investigators, the police, that the very family now crying about it may actually be the perpetrators. So we've got to be very, very, very careful when it comes to sharing information with anybody outside the examination sphere. And we tend to consult with the police about that. You eventually know what you can share. It's similar to the M&Ms. I mean, we don't give documents to people because those, but we can share clinical information, because at the end of the day, what the M&M does when you give them that information is something can be done much sooner to try and prevent similar kind of deaths. And with families, I don't believe one needs to be unempathic or unsympathetic. And what you can share is what you can share, but you can't tell them more than what you know yourself. And very often we are waiting for, you know, that with, for example, with DNA and toxicology, you can wait 10 years for a result at the moment. And DNA, many, many years. So those are actually the difficult cases, and very often there is very little we can do to share information other than to explain to them that this is the situation that we're in at the moment in South Africa and why there are delays. So very often what families want to know from me is, did my loved one suffer? Those are things that we can deal with as doctors. Those aren't difficult. They won't compromise the outcome of the investigation. If I discuss with the patient, you know, how things might have happened and how the decedent might have felt, or whether they were aware of anything. So those things, I think, depend on sort of almost personal and professional integrity and sympathy and understanding. But we can't share the actual details of an investigation with families because that would jeopardize it potentially.
Prof, I see there's some nice questions in the chat box.
Sorry, I'm struggling a little bit to get all my little things open. Let me see. Are all the forms mentioned available in the hospitals? They should be. Yeah. Oh, you've answered that one. Somebody asked it. Thank you.
So maybe one of the ones towards the end is, as a head of the health establishment, a hospital manager, what does the hospital manager do if he identifies that doctors are giving in to families' pressure to declare deaths as natural? And what's the risk for the hospital manager? What does he do as the head of the establishment?
Well, I mean, you've got a thing called vicarious liability. If this is sort of becomes standard practice at a particular facility and the authorities become aware of it, then they can, you know, they can take the hospital management to task. And I think that as a hospital manager, if you become aware of this coming kind of practice, let's appease the families and let's just get the body, you would have to intervene at a disciplinary level, if not at a legal level. You can lay a charge against such a clinician. You would be within your rights because it's a contravention of a law. So, you know, I wouldn't take it lightly if I had to become aware of this as a practice. If somebody makes a mistake and it's one mistake, that's one thing. But if it's practice to sort of concede, and I'm telling you, we almost have no SIDS cases in Gauteng, which is impossible. What it does tell me is that they're being signed out. I do understand. I understand why people are feeling so desperately sorry for those parents. The tragedy here is that there probably are child abuse cases slipping through the net here. And I think that's more of a travesty. But yeah, I do understand how doctors can feel under enormous emotional pressure to sign them. And I think a lot of them do it in goodwill and not realizing that they are actually breaking a law. Committing an offense.
Prof. Chetty, have you got, can I ask a question? I mean, one of the questions I want to ask is that, I mean, after, well, how long does it take after the forensic medical examination for the inquest process to be completed? And is that inquest information available to the public?
Yes, the inquest information becomes public at the end of the inquest. Okay, it becomes public record.
And it's available on record forever?
Well, when you say forever, it's probably archived, yes.
Yes,
I would imagine.
Available. It doesn't get
I'm
destroyed.
saying that, but I say it with reservation. I can tell you after the transfer from the police to Department of Health, we lost records prior to 2005 that nobody, they exist, but nobody knows where. We know they're in some major police storeroom in Alroda, and apparently that thing is the size of OR Tambo Airport, just the storage facility. So where are you going to go and find? So yes, it exists, but we can't find it. There's no way. I think now that we're in the digital era, we are much better about keeping a digital footprint and tracking our cases and backing up data. But certainly prior to 2006, we undoubtedly lost information and evidence. And unfortunately, part of it was that shift over from police to health.
To health, yeah. Prof. Chetty, maybe we've got time for one more question and then we can wrap up.
Yeah, I just want to ask, because this is also common amongst practitioners in the art. It's all around uncertainty and doubt again. Health professionals need to share information to justify the legitimacy of care by assuring the belief that everything therapeutically reasonable was attempted. To what extent do we discuss this? And what details do we share with them? Because this can be used against you eventually, particularly if we are not cognizant of our boundaries that we need to develop between us and the patient.
Sorry, you cut out quite badly on my audio. Can you just say that again? I didn't hear everything.
I think I need to get this this boardroom sorted out. I just want to know is health professionals want to justify the legitimacy of death by assuring the bereaved that everything therapeutically reasonable was attempted. I want to know to what extent do you share this information and what details do you share with them?
When you say share, who do they want to share the information with?
With the bereaved, with the family of the patient.
Oh, okay. I think that there's no reason why they can't be transparent with the family to say what they tried, what every effort was that was made, and you know, that despite every effort that the patient died. So what they share with the family is not a problem if it's the clinician. What we share as the forensic pathologists becomes much more of an issue, because what we find would be the factual findings in the autopsy, and we would have to go and testify on that, or write a report on it. Well, definitely write a report on it and maybe go and testify on it. But we would be far less likely to share any kind of detail about, oh, but your doctor could have done that or could have done so. That we won't do. But the treating doctor can discuss as much as he or she would like to with a family, to explain, you know, what went wrong, how they would have done it, or how they did do it, and that it wasn't successful. Unfortunately, but there's nothing that limits them. They're not at that moment in time, they're still the patient's clinician, and they are In fact, I think that they should be sharing that information with the bereaved family. They're not on the stand at that moment in time, whereas we, as the forensic pathologists, from the moment we receive the case, we're already dealing it with a case from a medico legal perspective.
Thanks, Rob. I think this has been a long night for you. I think we've cleared a lot of doubt, we've cleared a lot of uncertainty, and we probably understand much more than we started with. So I'm going to thank you sincerely, and I'm going to hand you back to Nilesh to bring the evening to a close.
Thanks everyone for joining. We've still got quite a large number of people online. So that just, reflects the level of interest in the engagement and the conversation that we've just had. I think it's been a very interesting topic. Thanks to Professor Vellema. Thanks to Prof. Chetty for chairing, and to all of you out there. Please look out for our next CPD in this ethics series of ethics conversations around clinical governance matters. And we definitely be doing 2 more this year, possibly 3 more, and we'll be in touch. Thanks everybody, and have a great evening.
Thank you very, very much. I really appreciate having been invited to speak here with
Awesome.
everybody. Thank you so much.
Thank
Good
you.
night,
Cheers,
everybody.
everyone.
Be safe.